Hi, how are you doing there? All right, so we just started going on the stream. There's only a quarter of the people registered have actually got into the actual channel at the minute. So what I need you to do, because we've already had a little bit of a worry on the audio front. So if everyone can just like, put a Y in the chat if you can hear and see us, okay. So or at least you can hear me while I'm talking. So just put a Y in or yes in, anything like that. Thumbs up as long as you can hear and see us. Yeah. Okay. Good, 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 good. All right. Everyone can hear that then. All right. So what we've got here as well, got a good friend of mine, Richie, who is going to be giving us a little bit of a story about what we're talking about, really, and what we have to cope with and deal with on a regular basis. So, what I'm going to be doing, right, is we'll have a chat with Richie in a minute, make sure that you can all hear him as well. But this is going to be the main thing is going to be about the research that I've been doing under the FCA, as well as obviously GDPR and everything like that, um, about these debt collectors and the discoveries of what some of them have already done and what one big player has actually got lined up and has already applied to do. Now, I'm not going to give you too much away now, or it'll be pointless doing the whole bloody thing. And I've spent ages doing this presentation. So you're watching it if you like it or not. Um, so, and this is going to make it even dirtier. Let's just put that way. That's a good way of actually putting it. So they're actually going to try and be even worse with people and try to hide behind. Okay. Now, again, I'll tell you, the a little bit of housekeeping. So, like, we're here now. We've opened this up to like the general public, so everybody can come in from anywhere. But we're here to help everybody, and everybody's got to be on here and being polite and everything like that. We don't have any snarky comments, any bullshit from anybody. Anyone tries to be funny in any way, boom, you're gone in a split second. We don't debate. We don't worry. Okay, we can deal with the fallout after. So just bear that in mind if you want to make any comments. And what we'll do is, Richie, you can introduce yourself now, and then we can check to see if they can hear you all right as well.
Yeah, all right, Pete. Yeah, I'm Richie, obviously mate of Pete's. We've obviously talked for many years about different stuff and gone down different processes and everything. And I don't know if you saw me and Pete did a live about PRA. I don't know, it'll be about a year ago now, won't it? Maybe a bit longer.
Yeah, I think it's about
Probably
two
is a bit
years.
longer to be fair. Yeah, it probably is, mate. When we was the initial court case was coming up and everything, and we did the CPR 18 rulings. The first judge, before it even got to court, ruled that they had to disclose everything that I had asked for. The case then got kiboshed because they didn't pay the fees. Then about a month later after that, they applied again and paid the fees and did an appeal against it, and whatever judge it was or whoever saw it said it was okay to go again. So that was live last what? Yeah, well, it'll be 2 years ago, because that was before then. So then it's just been sat in the background rolling on, and nothing really happened from the courts or PRA or anybody for about a good year and a half, something like that, until after it first got kicked out of court before it even got there. And then I finally got the end of May this year. I mean, the first time, like I was saying to Pete, the first time when it all came through, I got the notice of the claims allocations to a small track claim. The first time it came through like that. There was a judge assigned to it and everything else, all what needed to be done before we got there and what was said to be okay and what wasn't going to be okay. And then in May this year, just out the blue, when nothing had been aired, I'd rang the courts up many times and they didn't know anything really what was going on. They just said it's just sat there, now it's really happening, it's not going anywhere, it's not doing anything, they're just waiting for a hearing date. So couldn't really do anything about it. Probably could have done, but I wasn't really asked at the time, to be fair, because I'd had enough of them. It's been going on this for about 5 years, I think, all in all, and 2 years with the court side of things. And then the second time, end of May, start of June, it came through the next time, and it just came through like that. No judge's name, no nothing, no now, just basically stating that the case was going to happen 30th of June 2025 at 10 a.m. So obviously I got all my paperwork together, went for the court case. Two of my friends came with us. They came with us just to obviously moral support and everything, and just witness what was going on in the court and everything else. It's not a court anyhow. It's just you go in. Obviously, it's the county court side of things, and Hull's quite big, but it's got about 10 different rooms. They're just like classrooms with desks, and there's a bench goes across full width, and the judge, whatever, sits on the other side of it. So we got there on the Monday morning. It was 10 o'clock. The hearing was the first case that was up. Excuse me. Went in, saw the clerk, sat down, waited to go through. Finally got called through. Oh, I don't know, gone 10:05, something like that. PRA had hired a local solicitor. She was representing PRA, but PRA didn't turn up themselves. So we goes through to the courtroom, classroom, whatever you want to call it, whatever they class it as. Goes through. Obviously, I'd done all my witness statement. That was what was. I'd done all my witness statement, done everything. And it's funny, you know, when I said to you, Pete, earlier on, that they said, "Oh, we haven't received it, and we haven't got none of your witness statement here, and I can't see anything that you've put in or out like that." The first stuff that come through acknowledged that they'd received all my paperwork and everything ready to go. But when the actual case came up, lo and behold, even though I didn't even, you know, you can take it in and you put it in like a big letterbox, and then at the end of the day, it gets took upstairs and it all gets put to your case file and everything. But I didn't want to take the risk on that, so I actually got a woman down from upstairs when I ended my case filing and got her to stamp it with a court stamp and everything to prove that I had the receipt that they'd received the paperwork and took it. And he still on the day claimed that he didn't have any of it. So luckily I took stuff. I took basically that with me, with loads of paperwork in and all the stuff that I'd done as evidence and all stuff like that. So I had that in there with me. The case, obviously, it started, and as it started, the judge straight away said, "We're going to have a few problems here today." Didn't even acknowledge that I was really in the room, to be fair, apart from speaking name or whatever. I can't even remember at the time what he said. So that was the only thing. And then he just basically started talking to the solicitor as if I wasn't there whatsoever. The first thing he said to the solicitor was, "We're going to have a bit of a problem today because the claimant hadn't turned up. So the defendant can't ask any questions." And obviously she had no first-hand knowledge of what's been going on, apart from what she'd been given in a bundle from PRA, which was nothing really. They only put like I don't know, I think it's about, if you put it down on lines on an A4 page, I reckon it's about 4 lines, maybe 3, of what they claimed what was going on and all the rest of it. So we sat down and he said, "So that's the first initial problem we've got, is that we've got the claimant hasn't turned up." And then he said, "The next thing we've got is PRA have tried changing it from PRA Limited, who'd done the initial Northampton County Court procedure at the start, and then it gets allocated to your local county court when you defend it or you don't defend it or whatever you do." So they'd filed it under PRA UK Limited, and then they tried changing it to PRA UK portfolios. So that's what I knew that, and that had happened in the first part when it first got kicked out of court, because they never paid the fees on time, they never paid this on time, and then they claimed they never got none of the paperwork from the court, so they appealed against it, and this is how this came to this. So we sat there and he said, "Right, you've tried," and the solicitor just said, "Well, I've got no knowledge of this." I said, "Well, that's funny, because I've got the same paperwork as you, and it clearly states in there that they tried changing it, which is what I was objecting to in the first place, because we know what they was going to do. They're going to transfer it between themselves and create a deed of assignment, and that's what they try and do." But so that was the first. And then he said, "So that's the first problem we've got, because the claimant never turned up originally. They've tried changing it, but they've put no paperwork in to change the name over and to change the actual claimant. So in front of me, the judge said I've got no claimant and I've got no evidence whatsoever." So to me, it should have been case closed, claimant hadn't turned up, wrong paperwork, bang, dismissed. And that's what it'd have been if we'd have been doing it, which is guaranteed.
100%.
He turned round and just rambled on and then he started going on about different things. So I chirped up and said, "Excuse me, Judge, you know, I want to speak here." And just he was having none of it. He just went half ballistic. "No, we'll have none of that in here today. We won't be having this. I'll tell you how it's going to work. We're going to hear all what the claimant's got to say, even though the claimant wasn't there. So we're going to hear what the solicitor is going to say with no evidence and no nothing. And then when it's all done, I'm going to summarise it, and then I'll come to you at the end, as in me, the defendant, to see if you've got up to say." He said, then he turned to me and said, "Right, the only thing I've got a problem with you as well is because you haven't disputed the debt I have got no witness statement from you disputing the debt and everything." And I said, "Well, clearly I have, because I've got a receipt here that says you took the paperwork or somebody took the paperwork off me, and you've got it all." "Well, I ain't got it. I've got nothing here saying you dispute anything. So I'm having a bit of trouble here that you don't dispute it, and I've got trouble that they are here to say anything about it." So I'd said a few things to him, and he said, "Right, well, we'll just leave it at that." And he just went back to the solicitor as if to say, "Right, I ain't speaking to you, really." So he starts talking to the solicitor. Half an hour goes on. Bear in mind, she's got a laptop sat with her, tapping away, in contact with the outside world, doing anything she wants, basically. And I'm just sat there watching in disbelief as what's going on and stuff. So he's saying to her, she said, "Well, I'm trying to get in touch with the client to get the paperwork sent through." Bear in mind, the case has already started. And it was unbelievable. So he just basically spoke to her for half an hour and said, "Well, I'm not really happy with this. I'm not really happy with that. I'm not really happy with this. I'm not really happy with that." And after half an hour came by and she couldn't get no answer from PRA or anything, while you're in a court, how you're allowed to do that is beyond me. So he said, after half an hour, "Right, we're going to adjourn the case for 10 minutes for a recess for the solicitor to go out, ring PRA and try and get the correct paperwork sent through." So he goes out. I'm sat, and when he said about me witness statement and stuff and not disputing anything and not disputing this, in my defence, it was in my defence, and it was also in my witness statement with me Exhibit A, Exhibit B, Exhibit C, this is this, this is this, this is this. So when we goes out, I looked through my file and I found the witness statement and my defence with quite clearly disputing everything that was being said in there and everything else. So when we went back in after the 10 minutes had gone, I went and I said, "Look, Judge," you said, "I don't know if you got this the first time. Obviously, you're saying you didn't have it, so I'll give you it here. This clearly states that I'm disputing everything. I'm disputing what they're saying and disputing what Barclaycard and everything else." So I give him it, and he just took one look at it and he just went, "Yeah, I'm not interested in that," and chucked it back at me over the table. So I give one to him and the solicitor. I said, "What do you mean you're not interested in it? You just tell me that you've got a problem because I'm not disputing anything. There's the paperwork that you've already had, and now I'm giving you it again to say I disputed it. And you're telling me it's now no good." He went, "Yeah, I'm not interested in that. I'm just giving it back." Bearing in mind, in the half an hour while we're going on, he'd mentioned the notice of assignment, so I'd tried chirping up again and just said, "Look, Judge, I'm not happy with this whatsoever," and it basically shot me down yet again and said, "I'm not really bothered what you're going to say. Notice of assignment to me is enough. I'm happy that the notice of assignment is enough. I'm not really interested in the deed of assignment and everything else." Whereas in the first lot of stuff that was going to court, and I had a judge already given to me so I could CPR and send everything to him and everything, he quite clearly stated that everything I'd asked for needed to be provided.
Mm-hmm.
Obviously, it wasn't being provided. So we went back in after the 10-minute recess. He wasn't bothered about my witness statement, what I'd give him again to show that I did defend it all and I had disputed it. Then he came up with, then he just started talking to the solicitor again. He said, "Have you managed to get the paperwork off PRA? Have you managed to get in touch with anybody?" He said, "No, Judge. Nobody's got back to me. I haven't got the paperwork." All she kept saying was, "Well, it's only under the PRA umbrella. It's the same company." But I'll give you the judge, he pulled her every single time when it's not the same company. PRA UK and PRA Portfolios is two different companies altogether. So one's filed it and one's trying to claim it. So it can't happen. you know. So then he gets a book out, his big law book, goes to a certain CPR ruling and reads out that basically, under certain circumstances, if he believes that the notice of, even though he's not bothered about the deed, he believes that the notice of assignment's been sent out to me from PRA portfolios and stuff, even though I've never received it, they've never sent me any paperwork, they've never sent me anything saying they've transferred it from this to this. He said, if I'm satisfied that they've done it correctly in-house and sent it to you, but you just haven't received it, I can swap claimants. So that's what I'm going to do. I'm going to swap claimants from PRA UK to PRA portfolio. I'm happy and I'm satisfied that this is okay, and I'm going to do that. So I'm just sat there in disbelief, as in, how can you do that? There's been no proper paperwork file, but it did keep saying to them, you need to get your house in order. It's been going on for 2 years, this, because the solicitor asked for the case to be adjourned to come back at a later date to get the correct paperwork and the correct assignment done and stuff like that. So I'll give him his due. Whether he was doing it to save face and he was just going on to plough it out, and he was already going to say at the end, it can't go any further, you know, whatever, or give them, like me and Pete have said, PRA a chance to come back. So this went on for another 20 minutes or so. Just kept saying to the solicitor, PRA, it's a bit, can't remember what he said in the end, but basically telling them that your paperwork, you haven't got your paperwork correctly. I've got no evidence in front of me, and he must have said it 10 times. I have got no evidence from PRA UK portfolios whatsoever, and no claimant has turned up to say anything and do anything. So, in other words, it can't go any further. It's got to get kicked out. So this went on for like another 10, 15 minutes. Then he finally came to me and said, have you got anything you wanted to add to this? So obviously I brought case law up from Lord Denning, other case laws, what had been done with a deed of assignment, CPR rulings that I put in saying that, you know, I'd already asked for the deed of assignment, and yet they don't have to provide it if that's what you think. But once you've asked for it, they do, because you've asked. So it has to be, you know, if you haven't ever asked for it and you're saying a notice of assignment's not correct, but you've never asked for the deed of assignment, or, you know, in that sense, he's probably in his right. So I'm stood. I said, yeah. So I give him the case law, give him different things. I said, and also they've claimed in massive bundles that they've sent to me that the deed of assignment is included in this bundle. I said, and here's the deed, what they sent me. I showed it first, completely blank. I'd highlighted it all in green pen, and I read it out. Obviously, assigner blank, date blank, this blank, witnesses blank, witness blank, witness blank, 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 all the way through it. I said, so they've claimed they've sent me it, and clearly it's just completely blank and there's nothing in there whatsoever. Yeah,
that would have been the one that we sent, that we went over it the first time, didn't we?
Yeah,
we showed everybody all the blank deed. It was just literally about 100 and odd pages of blank rubbish.
Yeah. And it even states in there, 100 and odd pages, about the Companies Act 2006, Section 44. So it clearly states that they know that they've got to adhere to the Companies Act. That wasn't bothered about whatsoever. There was the privity of contract in there, 1999, third party rights and contract, that they've got to be named as it's stated specifically. So it goes to show that when we brought that up, they already knew about it in their contract, weren't bothered whatsoever. Nobody was bothered about that whatsoever. And so after about an hour and 5-10 minutes, when she asked for an adjournment, the one thing I'll give him, he came out of, he said, no, we're not going to adjourn it today. This has gone on for nearly 2 years. I'm going to make a decision at the end of all this, and that's going to be final. You can both, I can't remember if he said they can appeal it, but he said, obviously I can appeal it if the decision, what he comes out with, I don't agree with. Which, to be fair, I'd already resigned myself to just sat there and just thought, there's no point in arguing with him or even trying to speak or trying to do anything, because there's no way is he having anything today. He's just happy with what he wants to do. And that's all it is. But obviously, whichever way it went, I would have appealed against it and gone on a different term, because obviously there was no evidence, no nothing, no. So this had gone way past an hour by now. So at the end of it, when he summarised it, he said, well, as I'm going to finalise it off today, I'm satisfied that the claimant did did give you a notice of assignment. I'm satisfied that the debt does exist. I'm satisfied that you owe PRA. But on this occasion, I'm going to say under a technicality, because they haven't filed their paperwork correctly, then this case is going to be dismissed and it's going to go in basically in your favour, in the defendant's favour in a technicality. But if they had put their paperwork in, I'm quite happy that a notice of assignment's enough. I would have passed it and you would have been getting a debt against your name today.
Mm-hmm.
And that's how it got left and finished. It was just to see it and watch it in plain sight, that you can just switch somebody from one to another with no paperwork. They can have no evidence whatsoever, and you can still carry. It was unbelievable.
Yeah, I mean, but do you know what? As well, I mean, we'd said this before. Like the reason why he's left it like that is because the door's wide open now for PRA to like make sure that they go in and appeal that and file again. So. And this here shows two things. First of all, the corruption is 100% real. I mean, we've got a couple of cases like that as well from other guys that are in the group, and it's just some of it you've listened to, and it is hard to believe some of the things that these judges say. I think, wow, it's just, and people know this. Like, you're saying this to people.
Yeah, well, it did. One of the usual ones was when we did Lord Dennings and the case law. From the Queen's Bench, like that. Yeah, you've just got that off the internet. I'm not interested in that.
Yeah.
Where else are you meant to find it?
But what does that even mean, though? I mean, like Lord Denning's there's pages set up specifically about Lord Denning. What is he saying? Lord Denning was wrong? I mean, that doesn't make any sense. You can go onto the government websites and it tells you all about Lord Denning. It tells you all about the deed of assignment and what is needed. The thing is that the system is so twisted and corrupt that they allow the debt collectors to get away with this because of judges like him. That first of all, they don't really know what the law is, and even when they read it out, they don't understand it. The Law of Property Act 1925, Section 136, does not say that the notice is sufficient. It doesn't say that whatsoever. It's broken down into different parts, and it says it must be under the hand of the assigner. Right, and that's specific, and given notice to the debtor, That's the wording, In fact, I've actually got a comment. I added it up there myself, and this is actually from case law there, right? And this is from the Frischman versus Vaxil 2023. There's the actual citation, EWHC 2698. In brackets says CH. That means chancery. Okay. And this is at point 56 to 62. A notice of assignment is not a deed of assignment. Only a signed instrument executed by the assigner can give legal title to a debt. Without this, DCAs cannot enforce or sue in their own name. Right. So I think you should screenshot that, everybody, because that is the facts, and that is it from that case. So the problem comes now, though, and what we're going to show you is even more corruption that's already taken place and is about to be launched by others as well, before you even get into a courtroom. Now, that case itself, I'm going to share my screen. Let me just quickly check when I've got it like on there. Yeah, there it is. Okay, so do that there. Share screen. Let's have a look. There it is. All right. So I'll share that. That's actually on, it's called, I don't know if I'm saying this correctly, but it's Bailey is what it looks like to me, .org. That is one of the official websites that shares all of the case laws that come out. And these are set precedents. So this is, you can see the name between Richard Sandor Frischman and Vaxil Holdings, SA, and a few others, okay? He was the claimant, they were the defendants. And if you go through, you can read the whole judgment. It's obviously quite long. Look, that's going all the way down there. So we're not going to go over this, but I have shown you there. So if you look at the top, you've got the actual www.bailey.org. There's the case citation. So you can go and check it yourself. And it tells you there, look, England and Wales High Court, Chancery Division. So I'm just going to stop sharing and come back in, so I'm not just looking at words all the time. So under that principle, stare decisis, so they have a duty to follow the precedent set by the High Court. They haven't got a choice. There isn't something, I don't feel like it today. You know what I mean? It's like, oh, bloody hell, I don't like Hull, right? You know, you just don't get these choices. That there is a set precedent, and that is the law that they have to go and follow the precedent set by the High Court. Not only the High Court, but this is the Chancery Division. So, you know, what I've been saying for quite a long time now is, like, firstly, we need to go on the attack more. We can't sit and defend because we're far too vulnerable. I mean, last time I was in court, I got shouted at quite a lot as well for interrupting, you know. But when you listen to them lie, it's hard to keep your mouth shut, innit?
Yeah, definitely.
You know, but then they're in charge, and they can just say, right, get out, you know, and we'll do it without you, and, you know, completely and unfair. And that's the thing, is if we have to go and start attacking them in a legal way, right, but using their rules against them, and the only way to do it, well, all right, it's not the only way to do it, I shouldn't say that, but a very good way of doing it is GDPR, right? The data breaches that they actually create and commit, really. I mean, you might, I don't know, couldn't say it's a crime, but they're actually, you know, completely, in fact, no, I'm wrong now. I'm going to show you actually there, part 70 of DPA. It is a crime. It's a criminal act. So actually I am correct. So they, but we need to actually go after them, all right, on there, but also direct it to the correct court, because going into county court, and this is the thing that people have to get is, right, it's called a concurrent jurisdiction, which was coming from the Judicator Act when they joined it together, like, because it used to be completely separate, although it is still separate. It's a very weird thing, but equity and common law. But in the statutory court, statutory legislation is common law, right? That is the rules that they've got laid out in front. And it's like these judges have got the ability, or maybe they haven't got the ability, but they've definitely got like the actual jurisdiction that they can invoke equity, which is fairness and justice, and using your conscience, using the king's conscience, which is what the whole thing is supposed to be about. But they're just like, you know, Richie, sit there and shut up, right? You know what I mean? So it's absolutely ridiculous. Then this is what we need to do, is to move over to Chancery. Now, that court case there that I've just said, that is from the Chancery Division. So they are also going to be extremely protective about their judgments. They're not going to turn around and allow a debt collector to abuse their judgments. And they're literally, from a high court judge, they've said, no, you can't do that. So they're not going to take it from some snotty little debt collector, you know, that where they can do what they want. And you can tell now as well, we've got a few cases that have been put in and filed to go to what's called Business and Property Court. And the debt collectors are putting in N244s, like screaming to not allow it to go into Chancery. Why is that? Keep it in the county court. It's too simple. It's not, that's what their words are, too simple a case, not complex, because, you know, the saying Chancery is too complex. But it's not just about being the complexity of the matter. It's a data breach, and Chancery, or Business and Property courts, they specialize in data breaches. And the DCAs know for a fact that when we've quoted that case law of Frischman versus Vaxil, that they've got no instrument or deed of assignment, whichever way you want to call it. You know, I've had this argument with people say, oh yeah, well, we don't need a deed, right? You don't have to have a deed. You can have anything signed. Well, if you've signed it, it's a fucking deed, right? That is what it is. But like, call it an instrument and you get rid of this silly argument. If there's an instrument that's been signed and witnessed there, then, and it needs to be produced to prove that there is an actual assignment from one party to the other, from Fred to Bobby. Yeah, and you can't have anything in between and so it was just a friend's agreement. It was just a private sale or a debt sale or all those other stupid things that you actually hear from them.
Yeah, and it's
You know
got to
what
be
I mean?
witnessed in the correct manner as well, hasn't it? Which none of it's witnessed. They obviously, because the notice of assignment that they had from Barclaycard was from Stephen. I can't remember. No, Simon, somebody in it. I can't remember his name off the top of my head, but he'd signed it. No witness, no nothing, no note. And yeah, that was fair. That in the judge's eyes, that was allowed. That was fine. That's all he needed to see.
Yeah. Just this on here. So like Coke was saying, does that mean that the assigner is the company that has the debt? Let's clarify that. In Richie's case, yeah, it was Barclaycard, wasn't it?
Yeah, yeah.
Right. So Barclaycard would have been, if it was correct, that the assigner giving it away to the assignee, which is well, in this case, PRA. All right, just so you make sure that that bit is clear there.
So and they even state to you all the time that the reason they can't provide you one is because they bought it in a block, and your name ain't on there.
Yeah.
But then loads of times they've said we do have the deed of assignment, but we're not showing you it unless we go to court, and then they still refuse to show you it when they go to court.
Yeah, no. Look, it's got Daryl on here who's actually put about that what I was saying as well, and Daryl's actually went into court recently on there, and they actually said to him, well, all we have is like blocks of data. We've got spreadsheets, and you know, yeah, they're admitting it like in front of the judge. The judge, well, that's enough. You know what I mean? It's like unbelievable. You know what I mean? It's just like they don't really care what they actually say or do, but they've got it now in such a state that they can get away with this. You know, so it's I want to be careful how I put this. What's happening is it's actually worse than we think, because they also have to be FCA registered. Now, any company has to be FCA registered for various different things. And this is where it gets really dirty, because a lot of these companies are FCA registered under a general registration, but they are not registered to enforce debts in their own name. They've got a license to purchase the debt and to certain limits of what was the term they put it, but managing debt, but they're not allowed to enforce it in their own name. Now there's 3 of them are already in this one, and we have another one who's been watching them very closely and is about to launch. Now, I'm telling you, you'll know all of these names. I'm going to go over them now. And let me just quickly check to show what I should show you first. Let's have a look. That is the case law. I'm not going to go over that bit yet. Okay, should I say that part first? Yeah, I'm going to show you this part first. So I'm going to share this this actual document on there. Okay, so we will try and get to questions in a bit, right? But we're not going to be able to do it, or would never get through everything. So we'll try at the end. So just forgive me for that. I can't really go over every single question on there. So I think this is going to be the one. All right. So this is all the different debt collectors here. So it's like debt collectors, Search, Lowell, Cabot, PRA. All right. Why do they operate in this way? And what it is what they're doing is they're hiding behind themselves. So these debt collection agencies, right, they exist to buy defaulted consumer debt. Okay. And they do it in bulk. We've just said that there, pennies on a pound. All right. But not by a true legal transfer. What they're doing is they're purchasing raw spreadsheet data, then they attempt to enforce these alleged debts in their own name, banking on mass ignorance, right, court inertia, and a lack of legal challenge. Most people can't be bothered. Now, bear this in mind. 90%, probably about 99% of this gets done in a bulk center in Northampton, where most people never even know about it. And the ones that do know about it never answer or challenge the actual accusation against them. So the commercial reality is most debts are never actually assigned by a deed. They are just sold in huge data packages. The DCA's business model is entirely dependent on not having to comply with the strict legal and regulatory requirements for lawful assignment and enforcement. They actually rely on you just not knowing it and not caring. And then the laziness of the judiciary. Right now, this is the part that they don't have.
What's this on, Pete? What's this? Where you got this from?
This is from the FCA.
All right, this is off their actual website.
Yeah. So the FCA, why are they avoiding that FCA Part 4A permission? They need the FCA Part 4A permission to actually enforce any debt in their own name. Bear that bit in mind, because that's the important bit, in their own name. So what is it then? What's this Part 4 FCA permission? It's a regime under the Financial Services Market Act 2000, which is FSMA, which requires any entity engaged in regulated activities, such as debt collection and enforcement, to be FCA authorized and subject to strict rules. What the FCA's rules and why are they so tough? FCA CONC and principal rules demand fair treatment of consumers. Well, we'll never get that. Full transparency, a wish. Robust data protection, well, basically none. Proper records of title, assignment, and authority. Well, we've just heard all about that, haven't we, off Richie? Absolute honesty. Well, there we go. In court and dealings. Annual returns and open books to the FCA. Fit and proper person test for controllers and directors. How could any debt collector be a fit and proper person? Hey? Oh, wow, we can leave that one there, can't we? Severe penalties for abuse or misrepresentation, including, right, look at that, including criminal liability. And I'm going to show you more criminal liability in a bit. So if a DCA is is FCA authorized, every step they take is subject to regulatory scrutiny and audit. They must produce actual deed of assignment, FCA permissions, full audit trail, and show they are entitled to process and enforce. All right. If they abuse the process or mislead the court, they can lose their license and be criminally prosecuted. So why do Perch, Lowell, I'm not going to say these are the right names, by the way, but they may well be later, they tried to escape from that regulation. All right. They can get regulatory avoidance if their only hope of sustaining a business. If forced to prove lawful assignment, data accuracy, and standing, the majority of their claims would be destroyed at source. They know that their block purchases from the data, the spreadsheets of data, don't satisfy the Law of Property Act 1925 or the FCA rules. It isn't just the Law of Property Act. Lowell in particular has applied to remove, right? Look at that there. Lowell in particular has applied to remove its own Part 4A permission in recent years, a move almost unprecedented in the industry. They've actually applied themselves to lose their own license. Why would they want to lose their own license? Well, because then they don't have to actually be regulated as hard. That's why. And they're going to try what Richie just said. Well, I can't remember the exact, but PRA Limited, selling it to PRA Portfolio. That is why they do it. And this is what Lowell are doing. You'll know if anyone's dealt with Lowell. You've got Lowell Portfolio 1 or whatever it's called, and Lowell Financial Limited, right? Obviously, they're all owned by the same people, and they're just trying to hide behind walls. Okay? Why do they do it? Because they want to wish to revert to acting as mere debt purchasers, right? Debt administrators. And that means they are not subject to the rigorous FCA audits, mandatory compliance with CONC and the PRIN, customer redress schemes, direct regulatory intervention. The FCA does have power to do things when they want to do it, right? It's a ploy, right? If they're not authorized, then they believe that they can escape those obligations, but they do continue to buy, threaten, and litigate as if they did actually have real legal standing, and they don't even have legal standing. So they hope that the public, the courts, the regulators never even notice the difference. You wouldn't even know anyway. How would you know unless you've been like really like digging into it like I've been doing? Who would know? Like somebody gets a debt letter, you're not going to go in, oh, I need to go and quickly check all the FCA websites, you know? So it just doesn't happen. So they will often use front companies. That's exactly what they're doing. I'll tell you a little bit about this in a minute. Or obscure contractual structures to shield the real entity from the FCA scrutiny, right? And what they're doing is they're just trying to hide their and be behind plausible deniability. That's a good term. The government use that a lot. Plausible deniability. So what's the end game? They want the maximum profit with minimum compliance. All debt collectors do. That's why they buy it for like what, 2 pence on the pound or something. So by opting out of the FCA regulation, they gamble that the average consumer will never ask to see the deed of assignment or have FCA permission. Right? County courts will process claims on paperwork alone without forensic scrutiny. Where you just listen to there what Richie said. I mean, they don't even care. Right? They can wash their business model at regulatory risk while still processing millions of individuals' personal data unlawfully. Personal data unlawfully. So why it's both a legal and ethical scandal. This is abuse by omission, a strategy rooted in legal misdirection, regulatory arbitrage, and public ignorance. The likes of Perch, Lowell, blah, 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 hope that unless challenged, no judge consumer will force them to prove their right to enforce. In reality, the debt collectors enforcing a regulated debt without Part 4A is acting unlawfully under the FSMA and committing criminal data offence. Okay, it is a criminal data offence under DPA 2018, Section 170. All right, it's a criminal offence. You can all go and check that out. Right, don't believe me for it. It doesn't matter. Go and check it out yourself. DPA 2018, Section 170. It's a criminal offence. Right, they're also in breach of the clean hands doctrine under equity, which is why we always invoke equity in your claims. Never go to a county court seeking remedy from the court whilst refusing to comply with basic legal regulatory duties. They do not have clean hands. The solution, public awareness and legal checkmate. Once the public and judiciary realize the emperor has no claws, oh, I like that bit. The entire DCA model collapses. Every claim should be met with a demand of the executed deed or the instrument of assignment, not just the notice of assignment. Demand the FCA Part 4A permission, right? That's what they need to actually do the debt in their name. Objection to any data processing or claim in the DCA's own name without these. If they cannot produce these, their claim is void, the data processing is criminal, and their business model is finished. All right? So they literally, it's a deliberate ploy to avoid the tough rules of the SCA that are literally giving away their permission, their Part 4A, which is vitally important. And I bet it costs them a fortune to do as well. You know, that is the brutal reality of what they're actually doing. So, you know, Lowell haven't done this yet, but are looking at doing it. So if anybody's dealing with Lowell, right, you still have to rely on going back to, right, the actual deed of assignment. You know, that's what we need to know.
This is why I came on tonight as well, and it's obviously, like I said, we've chatted for years, haven't we, about different stuff and all like that. And whenever I found out, I've passed it to you. Whenever you've found that you've passed it to me, and different stuff. And this isn't trying to avoid stuff. This is just trying to bring it back into the right realms and the right play in it. Do you know what I mean? We won't mind if they came at you with whatever they came at you, and it was all above board and everything else, and they played the game, but they don't, do they? So we know it's all a game, and they just don't play it. That's it. You know, it's just. It's off the score, and this is why I came back on again tonight and spoke to Pete. I said, after watching that and being on the other end of it, it just was off the scale. And the only way, when I rang you up, then I said, we've got to go down the GDPR route. That's the only way to go. The 3-letter process. I mean, don't get me wrong, it worked for a good few years, and it worked a lot. And don't get me wrong, there is still a lot of judges out there who do play by the rules and do play and do the right things, because a lot of people are getting it kicked out straight away because they've got no deed of assignment and stuff. So we can't say they're all bad, can we? You know, there is some out there who straight away just go, you shouldn't be here. Do you know what I mean? What you're playing at? You ain't got what he's asked for. Fuck off, basically. Do you know what I mean?
Oh, absolutely.
But it's more and more that they're just not abiding by anything, and it's just, we're not listening to you. You're not here. Just fucking, we're just going to do what we want, basically.
But yeah, just to quickly go over this, Joanne, isn't it? Yeah, Joanne, can we watch this again? Yeah, it's going to, obviously this is live, but it's only on this actual StreamYard. It's not getting shared on YouTube or anything live, right? This is literally like what the class of webinar, private webinar. So you have to register, which you all did. So, but it will get shared on YouTube later on, okay? Just so you'll know, you will get to be able to see it again. And obviously it will go into the private group Checkmate the Matrix as well. And I think what it is as well is that the people are talking, right? These, like, we've had certain comments as well from judges and said, I'm actually one of them trying to get the transcript of his case, Darren, I don't think he's on tonight. And the judge said, I'm sick of these people watching YouTube and then coming in thinking you can do stuff in court, right? And it was just ridiculous. Same thing again. And like similar to what he said, was getting said to you. Then when he's doing the appeal and getting the transcript of what he said, it was all removed, right? They took it off the transcript. Do you know what I mean? That's just like, it just shows you that the actual disgustingness of it, you know. But what I need to do is make sure that I do actually tell everybody what the other names of the debt collectors are that haven't got a license, because this is not only can you use the deed of assignment, and these three I'm going to tell you now, they have not got a Part 4A license, so they are not allowed to put their name on any claim. All right, so I'll go over them now, and I'll explain the real deep down part of it as well. So if I click that, and then do that, so it goes full screen, get the handsome faces off the picture, just let that, there we are. All right, so that's who we are, Checkmate the Matrix, and what they are doing is they are filing claims, and they have got no right to file. That is a fact. They've got no right to file this claims whatsoever. So the thing is, though, right, we've got over 1 million CCJs. You can go and check these out, go and have a look. And most of them, if not all of them, are unlawful claims that are actually being filed. And I'm not just talking about the ones of the deed assignment. I'm actually talking about these ones as well that haven't even got the license. They shouldn't even be filing it if they magically did have a deed of assignment, which they'd never, ever, ever have. So we have got some of the biggest debt players in here, debt buyers in here that I'm going to tell you. And, you know, they have got no license, or they have not got the required Part 4A permission to enforce in their own name. Well, what I mean by that is when they actually file an N1 claim, which a lot of you have looked at, some of you have even done, you have to put your name down. Who is the claimant? They are not allowed to put their name down as a claimant. That is what not having a Part 4A permission means. They do not own the title. They do not own the legal title. Do the courts check these claims? Do they? Hell, right? They do not give a monkey's. So it's literally like systemic abuse on an enormous scale. And we know that 99%, if you know, are actually processed through Northampton in that business centre, and people virtually never ever know that it's happened. They get a CCJ that they didn't know. A lot of them go on their credit history or credit file and go, "No, I've got a CCJ," right? Because it's all just done in paperwork. You don't go anywhere. So what we're doing is, and what you've just heard Richie saying there, it's not even apathy, really. I mean, I don't get it. It's just literally ignorance. And I know better than you, so you can shut up. You're just coming into my courtroom. It's mine, which it's not. It's our courtroom, or hearing room, right, is what they call them. But, you know, it's complete judicial apathy. They do not care. A lot of them, right, they are overwhelmed, and, you know, they don't give a monkeys. They want to get home, get the bottle of wine with a dinner, right, sit down and watch Coronation Street, probably. That's the type of lives that they're leading. They do not give a toss. Now, because of the huge scale, and probably because of a lot of money, you will have, you know, money getting paid to certain people. Let's just say that. So you've got regulatory silence. The FCA, they aren't really doing the monitoring or policing that they should be doing, and there is a huge gap in this actual court cases that can actually get done. All right, and obviously, what you're looking at, it is a proper setup of corporate deception. They are doing it on purpose to hide themselves behind walls, right? It's like having sister companies and, you know, these holding companies, and these aren't offshore companies, but I'm just using it as an allegory. So they have, like, as if you were hiding behind a company, behind a company, behind a company. And they do. You know that these debt collectors use these complex corporate structures. That's why you've got them called Portfolio One, and then Limited One, and Finance One, and all these stupid names, because they're all trying to hide behind what is true and the nature of their claims, which is they do not own the debt. They've just bought data. And this is the funny thing they tell us about looking on the internet. That's where they bought their bloody debt, on the internet. So the consequences of this is, though, is right, you've got 100% unlawful lawsuits. So you're getting sued in these courts, right, hearing rooms, right, by companies that should not even be talking to you. They have not got any legal right to talk to you, talk about you, or put any claim against you whatsoever. So it is completely ending up in an unjust legal battle, and you are the only one losing, because the judges sitting there with stupid smirks on their faces don't care less and don't listen to any normal law. Right, I'm going to check that up, what Richie said. Like, your judge is saying, oh, I've just looked at my big black book, and it says there, if I feel, or if I am happy that they got and Richie got a notice of assignment, I can do whatever I want and swap the company. I'm pretty sure that that's a lie. So I'm going to check up on that CPR, and we'll see how we'll get on with that. But 100%, and this is why we always should be going for the GDPR. It is illegal data processing. If they do not have a legally executed instrument or a legally executed deed of assignment, then they have no legitimate interest. That is a GDPR term. They have no legitimate interest to be processing your data. So not only is it actually a breach under privacy, it's a criminal act. And we showed you already under the DPA Part 170, it is a criminal act. So you end up, because they do it mostly through the business center with the CCG you never even knew you had. And there, if you do actually get into court, you're going to get one anyway, because they don't give a monkey's what you say. As you've just heard it, and a couple of other people that are on the audience tonight have actually been through. Daryl's definitely one of them. So this is all about them setting up these legal traps. So they are lying to you. They've not even got the proper permission, their licenses to actually do this. So they have the FCA. You can look at this yourself. Part 4A permission. Debt collectors must hold Part 4A permission to legally enforce, pursue customer debt in court in their own name. So they cannot put themselves down as a claimant. Without it, they have no legal standing. So they can shout and scream, do whatever they want. They're not allowed to ever take you to court. So I'm going to explain a little bit about one of them soon when I show you all of the names. Right? They've never, ever, ever got a valid deed of assignment or a valid instrument of assignment, whatever you want to call it. So a proper deed of assignment, it's required under the Law of Property Act 1925 and the Law of Property Miscellaneous Provisions Act 1989. And it needs to be done that way for a legal transfer and the enforcement of a real debt. That never happens. They do not have any legal title, never mind a proper legal title. They haven't even got any legal assignment. They haven't even got an equitable assignment, never mind a legal assignment. So if they can't show legal title, under that case law we've just shown you there, they have no right to sue in any way, shape, or form. All right? There's a pretty picture for you. Look at that. So the masking game, what they're doing, what they're hiding behind, like they said, they're hiding behind, they're spying. Like I said, they're going behind all these companies, right? Lowell Portfolio One, Lowell Financial Limited, PRA Portfolio, PRA Limited, right? Debt claims they're just being submitted by agents acting on behalf of the hidden entities. They're actually trying to hide behind the wall and hiding or masking the real identity, because they haven't properly got any legal entitlement to be after the debt. So you've got your sister companies, they've got related companies, even the solicitors that they use, they're actually in the same office owned by the same people. So it goes on to this, like such and such, TM Legal and all these, but they're already owned by the same person who wrote to you in the first place. So when they say, oh, we're going to speak to our legal team, it's him, right? He's just like told his mate across the actual office, now you got to speak to these people now. So the law firms, right, they are just used like as shields to obscure and lie, but they actually are all part of the same group. It's just absolute nonsense. So who are they? So what I've been doing, I found this one debt collector, and I thought, do you know what? If there's one, there's more. So we've been hunting these down and going over all of the FCA licenses, trawling through the FCA website, checking out every single one of them. And unfortunately, most of them are fully licensed. Just, you know, there's not hundreds of them. You know, most of them actually are completely licensed. However, we do know, even if they're licensed, they are not getting the deed of assignment. So they're still like breaching all their own regulations, but they are unfortunately licensed. So we've looked and we've gathered evidence, and we've actually gone over it and documented all of these evidence reveals a systematic disregard on purpose. Like I said, Lowell are actually watching these other three groups and they're copying them. They've already applied to actually get rid of their own license. They're doing it themselves. They're not getting punished and getting it taken off them. They're asking to get it taken off them so they can hide behind these other ones and the different companies they've created. Yeah, absolute madness. So what we've done is we've literally decoded the matrix, if you want to call it that. We've looked into it, we've discovered them, and now we're going to tell you about them. So who is it? The big ones that behind these, one of them is called Interim UK Finance Limited. Now, again, we've got the case law against Interim themselves, right? They actually have been into court and been found in the wrong side, all right, because they don't have this license to put the Part 4A to put their own name on a claim. And they still do it every day. I've actually got members of our group that are fighting Interim now. Luckily, when we've actually put together the case laws and we can get them before they get to a court, you know, we've just had one lady in the group, £17,000 that Interim were demanding from her. A couple of notices that we created, an equitable notice, and all of a sudden it's got, we're going to make a good decision and we're going to close your debt for you, right? £17,000 they just walked away from as soon as they actually seen the case law we were putting them under. So this is the actual power of this knowledge. Another one, Perch Recovery Limited. They're a huge group, you know. Now, Perch themselves, what they have is other sister companies. They have, and you'll all know these names, by the way. ACI is the group that Perch use as their front. ACI, funnily enough, are fully licensed under Part 4A, but they never use ACI to actually go and put onto the actual claims. It's always Perch. But they use ACI to pressurize it. And obviously, most people do pay very quickly because they're scared, they've got intimidated, they're getting the threats from ACI. Now, who is it that actually goes and files the claims for them? It's TM Legal. What's the address? It's the same as ACI. Really? And it's also the same at Perch because it's all the same people, all owned under one little roof. But they are, like in the case of PRA that Richie was saying as well, the judge stated, but they're still all separate companies, right? But they're all owned by the same people, and it's Perch Recovery that put themselves down on the claim, and they cannot file in their own name. Now, here's one that I know I'm dealing with a lot, which is LC Asset to SARL. They're not even in this country, right? They're based in Luxembourg. So they have got absolutely no jurisdiction and no Part 4A permission to be filing against anyone. And I have seen dozens of claims. I know people that are paying them, right? Because they won't listen. You know, they say, oh, no, I need to pay them, blah, blah, blah. They're not even allowed to put a claim in at all, right? They're not even in this bloody country. And they use people like Arrow Global and Link Financial to actually do the dirty work, right? That's like LC Asset 2, SARL. They have got, first of all, no permission under the FCA to actually file against you in their own name. And, right, the likes of Perch, for instance, can't say, well, we'll put it in ACI's name because there's no deed of assignment. They can't put it in someone else's name because they are the owners and they purchased it. So it can't work like that. It's completely wrong. There's no way they can do that. So you can't try and say, well, yeah, Perch can do it because they'll get someone else to actually collect the debt. Can't do that. That becomes then a third-party interloper with actually less legal standing than Perch have, and they've got none. No valid legal title whatsoever, bloody ever. And that's what I was telling you about before. Lowell, they've been watching them. Lowell are huge. You'll know this. You're right. You've all heard of them. Now beginning to adopt similar questionable practices because they've been watching these companies get away with it. And they're thinking, wow, do you know, that's good. So what happens is the FCA don't have to look at them as strictly because they haven't got the license to do it. But then they don't monitor what goes on in the courts. They don't look at every single an N1 filing to put a CCJ. That 1 million CCJs, right? And it'll be going up every year as well. So, you know, what you've got to do is you've got to actually know all of this information and be ready to act and to stop all of these rogue DCAs and hold them accountable. And only you can do it. You know, we can help you. We can give the information, but you've got to be the one that acts on it. So what it is that you can do, you can join us, join the actual group, join Checkmate the Matrix, get access to all of the resources, the templates, the support network. It's dedicated to exposing and fighting all of the unlawful debt claims. Arm yourself with the strategies, right? Use our tested strategies, legal templates to defend yourself against them, and know that you can doing it together, right? We actually have regular meetings all the time, and we go over all of this all of the time, and we do help. So there's the link there, or anybody that's in here and they've got your own link, you can stick your own link up because we also pay commission to anybody that like sells or signs up underneath you. I'll get a quick drink there. Okay, so hang on a second. I'm just going to make that smaller and then I can stop sharing. Oh, where's the sharing gone? Yeah, can't find it. Move myself, add myself back in. There we are. All right. Oh, there it is. Remove. Got it. There we are. And then make the page bigger. Cool. Back to the handsome chaps on there now. All right. So the is there a Canadian arm for this? No, but like I would say GDPR is not for, it's only for Europe. But right, what you can do is look at your privacy laws, because I've dealt with a few people that are in Canada and the privacy laws are still quite as strong. All right, still quite as strong. So have a look at that. Now, just on that information, has anybody got any specific questions on what we've been talking about? By the way, don't give us anything, you know, weird and wonderful. You know, we're not going to start going off onto tangents. We're trying to there's the case law. I'm going to go over that case law just before we finish. But if anyone does have any questions, let me know. Yeah. So yeah, again, there we go. SEO link number 2 and ACI. Well, there you are. Right. Brilliant. It's good. Cool. Let's try and hide. So what does that say there? Cabot have stated that they have a deed of assignment, but I cannot see it. Oh, surprise, surprise. Despite going through the entire SCR GDPR process over several years, what can I do next? You mentioned the ICO previously, or do I now need to take them to court? Which court? Thank you. 100% you got to take them to court. And the thing is, when you're doing the GDPR process or SCR process with GDPR doesn't take years. right? It only takes a matter of months. You would send off an equitable GDPR related SCR, and you send number one, which they've got a month to reply to. Then you would actually send the follow-up saying, "Look, really disappointed that you didn't actually reply, blah, blah, send it. We'll give you an extra 7 days. After 7 days, right, then you're going to send the letter before claim. And the letter before claim, right, you're going to give them another 7 days. Now, a proper pre-action protocol has to be 14 days long. We split it into 2 for you. Why? Because we add on an equitable estoppel. An equitable estoppel, what it means is once you've actually filed an equitable estoppel upon them, you're going to give them an extra 7 days, which makes it a full 14 days under PAP, pre-action protocol rules. So they had the proper time, but they're also now not allowed to bring forth any evidence that they haven't given you in the previous period. That means the first 30 days as well as after. They're stopped from bringing any evidence forward. That's what an equitable estoppel does in this situation. Then after that, you're going to file an N1 into the business and property courts. It's going to go, because you're filing for a breach of data, you're not filing on a debt case. You're not filing to prove did you or didn't you own it, or who gives the monkeys like what Barclays Bank did or anyone else. It's got nothing to do with them. They're not here anymore. Right? They've closed down the account. They've sold it. They haven't, but they've sold a block data, and they've got the bloody insurance claim as well. So, you know, they're quids in. They couldn't give a shit. But that's what you're going to do. File it in the correct one, because we are going to use an equitable process where they cannot hide behind these stupid comments like a notice of assignment is enough. It isn't enough. Okay. Oh, clicked on the wrong thing there. Can I bring up GDPR in a county court at a hearing to set aside a CCJ? Yes, most definitely. I presume it's you trying to set aside the CCJ, Sanj. So yeah, you definitely you can bring up equity as well. But the GDPR part, if you're trying to get it set aside, what you need to do is question the assignment, because that's the only way you can use GDPR, is to question the assignment. Without the legally executed assignment or legally executed instrument of assignment, whatever we want to call it, then there's no legitimate interest for them to have your data. Therefore, it's a breach of GDPR. You know, and that is the fact, and that is the law. However, as you know, what Rich just explained to you, the law sometimes isn't the law, like, because they don't give a shit. But it is true, and that is the law. There is no getting away from it. So to me, you know, I would actually be filing my own claim against them for a GDPR breach, instead of trying to, I mean, you know, set aside the CCJ, but there's other ways of skinning a cat. I hate that term, shouldn't say that, but you know what I mean? There's more ways than one of doing it, you know? We are talking about, right, just on this comment here, we are talking about like consumer debt. Okay, it's consumer debt. Like fines do not have a deed of assignment or any GDPR issues, you know, along that line there. All right. So, you know, I mean, I just want to stick to what we're doing. We're going to have like another session on like the utility bills and what the actual courts do. Well, not courts, again, these utility companies create fake warrants, but I mean, it's a different issue. So we don't want to get too like mixed up with everything, or we're just going to be overwhelmed. All right.
Going back to them sister companies as well, Pete, it was proven in court with mine, because I will give the judge one thing all the way through it. All he kept saying was, when the solicitor kept trying to say, well, even though they've tried changing the claimant, but they haven't done the correct paperwork and all the rest of it, but it's just an umbrella company, it's still PRA. That's what the solicitor sat there and said with her own words, you know what I mean? It's just it's the same company, really. It's just under the same umbrella. And I'll get a judge every time she said it, he pulled her straight away and said, I'm sorry to tell you, but no, it isn't. It's two different companies. If you go and look on Companies House, they are registered individually.
Yeah, I mean isn't it weird though? You see, is why is he actually doing that? And as if he's trying to say, well, I'm correct, you know, and I'm the judge, and I know what the law is. But then they're just completely ignoring the other rules. You know, it's like, well, I don't want to know about Lord Denning. Oh, really? You know, I don't want to know about like case law. I don't want to know about precedent set at the High Court. And I know that I have a duty to do what I'm told, basically, and he has. But like, you know, but I'm not going to allow them to like split companies, even though he did in the end anyway.
Yeah.
It's
But even
just,
though he split it, he then said, because they've got no evidence and no claimant here to start with anyhow, it's going to go out on a technicality.
he's probably like, I mean, we'll never know his own mind, but he's probably
Well,
wanting
you'll
to
never
like,
know, will you? Because he's just trying, you know what I mean? You can't climb into somebody's head and find out what they're doing. But like I said, at least all I can say is the universe was on our side that day. Do you know what I mean? But on a lot of other people, this is why we came on to do it tonight. On a lot of people who we know have gone there and know what they're on about and know everything else. They've just been shut down, not allowed to bring anything up, bring anything in, and just told basically, no, that's not happening today. That ain't how it's going to be.
yeah.
And as we've said a load of times, haven't we, before, obviously, you started getting into the GDPR side of things and everything. It is their game, and they can change the rules whenever they want and decide what they want to abide by. Do you know what I mean? We can appeal against it and everything, but a lot of the time, yet again, people ain't got the time, the wherewithal, or the energy left anymore to appeal it sometimes. You know what I mean? So it's a big swings and roundabouts game, isn't it? Do you know what I mean? But this is why I came back on tonight to just say to people, if you're still going down the 3-letter process, just be aware that, you know, it doesn't always go your way and it doesn't always happen your way. And if you do, then it does. If it don't, it don't. But if you do go down what Pete's been trying to get down everybody's throat for the last 18 months, 2 years on the GDPR side of things, you've got a 99.9% probability that it's going to come out on your side because we can't argue against it. It's set in stone. It's there. Fact. Done. Hence why, like you said, they're trying to have it set aside before it even gets to that court.
Yeah, definitely. And they're panicking now, you know. So Isra said, I have requested any signed contracts that Cabot have of me agreeing to my data to be shared. They responded by saying, when I signed the original contract, it states in their contract that any details will be forwarded with third party if there are any breach. Is that correct? It is and it isn't. But I mean, you don't even have to worry about contracts. Forget about all of that, right? Concentrate on the case law that we've just shown you. I'm going to go over it in a second again before we finish. And also that they're actually breaching your data by them not having the legal requirements to actually process the data. Doesn't matter what the thing is, what Richie mentioned it before, it's like the privity of contract and also the third parties. 1999, is it?
Yeah, third parties rights Act 99
needs to be specifically named. You can't just say, oh, we're going to share it with any third party. It needs to be specifically named who is going to be shared with in any contract. So they're kind of using what's written, but it's twisted, you know, again, another lie. But concentrate on the GDPR side. Concentrate on the fact that they haven't got the legally executed instrument or deed of assignment to actually have the ability to process the legal ability to process the data. Because they've got no legal title, there is no chain of title, which means that they don't own the debt really, then they can't enforce it. Simple as. And if you're dealing with the likes of what we just showed you, Lowell pretty soon, right? But you've got Perch, you've got who's tied to ACI, so ACI are like that. But the main ones that if they put the name on it, Perch, Intrum, and that LP asset, then you don't have them anywhere near you, right? It's like they have got no right to put their name on. They haven't got a license to be enforcing it. Okay. So I just want to finish off. Just we're going over. Let me have a look. Key. That is it there. Good. Just have a quick look at this one, just to make sure that this is it. And what I'll do is when I will share this on YouTube, and I'll attach the documents to the well, put it in the description, don't you, on YouTube? But when I put it into our Checkmate the Matrix, I'll actually put the documents in attached to the video. So it's a lot easier to see and watch if you go on to Checkmate the Matrix. Now, let me have a quick check. I'm just going to share the screen again, this last little bit on the key extracts. Okay, so again, we're going to look at this and you can go on. This is direct from that case. This is not made up in any way. This is direct. So key extracts from the Frischman versus Vaxil. Here's what Master McQuail said with the most compelling points for your argument, right? Section 136 of the Law of Property Act 1925 provides any absolute assignment by writing under the hand of the assigner is effectual in law. I am satisfied with the authorities to which Mr. Brown referred me, mean that an effective assignment under Section 136 requires it to be in writing and under the hand of the assigner, and that the assignment here signed by Mr. Frischman as the assigner's attorney does not satisfy that requirement. In view of the authorities from Wilson onwards, I do not accept the wording of the 1971 statute should be treated as rewriting the 1925 statute in the absence of any express reference to the earlier statute. Okay. And further, there is no legal requirement that an obligor is to be provided with a copy of the assignment itself. I conclude that the letter on the 8th of June 2020 would have amounted to good notice had Section 136 been complied with. Was good notice of the equitable assignment, which I have concluded is what had taken place. An equitable assignment only, in other words. And the killer point, paraphrased for clarity, excuse me, a notice of assignment, NOA, is not sufficient. The court draws a clear distinction between the assignment itself, which is the instrument or deed, which must be executed in accordance with Section 136, and a mere notice to the debtor. If the assignment is not executed under the hand of the assigner, that means it has to be written and signed by the assigner themselves. It is not a legal assignment. Without this, the claimant cannot sue in their own name. They are, at best, an equitable assignee and must join the assigner to any claim. Now, what that means is join the assigner to any claim is that they have to get the original bank to actually join them if they wanted to try and make a claim. But they're not even an equitable assignee really anyway. And I'll stop sharing there so I can just come back in so I can explain that just one more little bit. Right? Just so you know, and I'm going to ask Richie here, you would have got a letter from Barclays stating they'd sold the debt and they'd closed the account, yeah?
Yeah.
Right, and that's what everybody else does as well. They get a letter saying we've sold the debt, the account's closed, nothing for us to do with us anymore. So they can't then go back and say, oh, by the way, we've reopened it again, you owe us the money again. They can't do that.
Which is quite funny as well on them, all them documents when we went through nearly 2 years ago now. It clearly states in there that PRA, I don't know if it does in any other debt collectors one, because I ain't had them, but the one that we got off PRA clearly states that they have got to ask permission from Barclaycard to take any court action.
Yeah, and just let's go back to that. And it was about a couple of years ago. Can you remember? We actually, or you got whoever it was that was in a bad mood with Barclays or a bad mood with PRA, and they sent you all the templates that Barclays created and gave to all the debt collectors. The template that we get accused of using, right? They actually had all the templates. Didn't they? Can you remember that?
Yeah, 100%.
Incredible. And the information as well, that if PRA didn't have the ability to actually fulfill their obligation to actually get you to pay, they got refunded by Barclays as well. Yeah. Listen to that, people. Right. So they don't even really buy the data, never mind not buying the bloody debt.
No, it's just like, well, even on the thing when it sells you, and even what they don't even, when this is the mad thing, you see, PRA or whatever sends you a notice of assignment, but anyone that I've ever had from a bank like Barclaycard or whatever, all they say is this is a notice of transfer. In other words, we are transferring it. So they haven't signed it over, they ain't giving it away, so they don't really give anything away, the bank. It's the debt collector who claims that it's a notice of assignment's been sent and the notice of assignment's been given by the bank, but the bank only ever sends to you we have transferred your account.
Mm-hmm.
And that's what they have done. They transferred it, but obviously it goes back to them if they can't get cashed out on it or whatever else.
Absolute.
So it's just word salad, isn't it? That's all it is. It's just word
just
play. That's all it is. Yeah, just twisting everything. But obviously on that day, it's how that judge looks upon it and passes judgment, doesn't he? But he's meant to do it by the rule of the law, not by what he feels like on that day. If that makes any sense, do you know what I mean?
Yeah,
they're bringing personal opinion into it instead of just sticking to the facts of the law, aren't they? If you know what I mean.
It is
like I say,
personal.
I keep going back to man, but in the end, I can't knock him. In one way, it blew my mind what happened in there, but in the other way, it didn't at the end because he did keep pulling it back, saying, "Well, I've swapped it over what you wanted and all the rest of it." And unfortunately, you've got no paperwork, no evidence, and no nothing here in the claimant in here anyway. So we can't do anything about it. So it gets kicked out.
Crazy. But just bear in mind now, what I'm going to do is when we finish and I'll share this, we've got special SARs that we've created just for those 3 debt collectors. What I mean by that is it actually brings it up about the Part 4A permission. So you're going to literally put them on the roll. So this is it's a different SAR, and we'll put that there so you can all get access to it. So anybody that's watched this tonight, we will share it as well on YouTube, and it will literally, that is how you handle them, not just a basic SCR. I mean, you can go on to ChatGPT and put in create an SCR or a DSAR, whatever you want to call it, and it'll do a half decent one. But this is very specific and shows you exactly what you have to write to them, because they have to be brought up to account. And once they see that that they can't sue in their name, they're finished. What are they going to do to you? Right? Quickly, pay us some money, or we're going to call you some more names and make a threat. It's literally that. They've got like the no power, no authority. They haven't anyway. They never ever had. But this actually proves it even more. So I will attach them proper, dedicated SCRs that we created just for these companies: Interim, Perch, and LC Asset. All right. Okay, so we're going to leave it there. You got any last words then, Richie, before we shoot off?
No, just keep on fighting, innit? Keep on sharing all different knowledge and different, obviously, all the stuff that comes to light, to help fight against these parasites. Because unfortunately, like we've said from day one, Pete, the only reason we've gone all this is because unfortunately people are taking their lives over this nonsense every single fucking day, and that's the sad part about it, innit? That 90% of it, the 99% of it, like you've just proved, shouldn't even go to a court or shouldn't even go to anywhere. Do you know what I mean? So that's the big picture of it all, innit, Rick?
Yeah, most definite. Okay, so just bear in mind, someone's saying that these new letters, the SOs, yes, they are. They're created just because we found out about like them not having a license. So they're different to everyone. You can't send it to like ones who have got a license. You have to use them just for them 3 specifically. Okay, but I will add them onto this, be it on YouTube or in the private group. Okay, and then you'll know that how to actually use them. Because I am as well building a brand new app that's going to be, I don't know how long it's going to take, but I'm working and learning with these brilliant like coding experts, amazing people. So they're helping me immensely. And this app is going to get launched, and it's going to be a web app, not a phone app. And the reason why is just because if you put the phone app out there and you have to charge to go on it, because they're very expensive to build. But then whoever has it, Google Play or Apple, they take fortunes off you. It's like ridiculous to charge you even more. So
I would guess once you've registered it with them to put it on their app, they own it, don't they, really?
Yeah, exactly. And you lose all your code. So it's going to be a web app, and then we can control how to actually handle it. But anyway, I had a little bit digression, but it's just let everyone know what we're working on. So anyway, thank you everybody for watching. There's like quite a lot of you on there, and the replays will all go into. I think I actually got your email, so I'll send a copy to everybody. I think but it'll definitely go on to YouTube, and it'll go into the private group. All right. So thank you very much.
Well, cheers for having us on, Pete. Take it easy, people.
Brilliant to talk to you all the time, anytime. All right. See you all.